Hello and welcome to Civility and Solutions, a podcast brought to you by your Court Services section of the Supreme Court of Ohio. I am your host, longtime justice enthusiast Kate Munger. This is a podcast about inspirational ideas for courts from across our 88 beautiful Ohio counties. Today's topic relates to the legacy of Chief Justice Thomas J. Moyer as it relates to mediation. Chief Justice Moyer served on the Supreme Court from 1986 till his death in 2010. He led many changes in Ohio's judicial system, including the implementation of mediation programs in Ohio courts, the development of school-based dispute resolution programming, and the creation of the Uniform Mediation Act. Our guest today will challenge you to consider how to advance Chief Justice Moyer's groundwork in dispute resolution 10 years after his passing. The views expressed by guests to this podcast don't necessarily express the views of the Supreme Court. We are happy to be able to use this platform to share solutions and challenges with courts and any listeners who want to stay on the cutting edge of dispute resolution and court services issues. Welcome to Season 1, Episode 16. Our topic today, the future of Ohio's dispute resolution landscape, advancing Chief Justice Moyer's legacy. Joining me today are three of Ohio's matriarchs of mediation, Eileen Pruitt, Esquire, Wendy Hawbaker, Esquire, and Marya Coleman, Esquire. Thank you all so much for being here today. Eileen Pruitt is a graduate of Indiana University and the Ohio State University College of Law. She was the first coordinator for dispute resolution at the Supreme Court of Ohio. And Eileen, what was that like to blaze that trail at the Supreme Court?
It was pretty wonderful. My office was a little bigger than a closet. We got started though, and Chief Justice Moyer was really supportive, and he looked at what his advisory committee and the staff, which at that moment was just me, thought were directions that the court should go in setting up dispute resolution programs. And I think we were able over the next several years to really do the hard, I don't want to say groundbreaking, but laying a foundation by careful design, implementation, and research on programs to put Ohio in a great place among other states to see what would work in Ohio courts.
That's really fascinating. After the Supreme Court, you then worked as the manager of the Small Claims Division and Dispute Resolution Department at the Franklin County Municipal Court, starting in 2005. And then in 2008, you added the responsibility of manager of the Franklin County Foreclosure Mediation Project. But you're retired now. Congratulations.
Thank you.
Looking back, what did you like about your jobs at Franklin County?
That was really a direct services position. So instead of dealing with the mediators so much, I was dealing with constituents. And the municipal court is where most people go to court. They don't see much else. They would rather not see anything more than traffic or a small claims case. And we were able to offer mediation first in small claims cases and then in all the cases on the judge's dockets that they referred to mediation. And we had volunteer and contract mediators from the community who were a joy to work with. And I think we were able not only to help the judges get some civil cases off their dockets, which were really busy with criminal cases, but we also saw people get results that they wouldn't have gotten in court.
And Eileen has mediated cases for municipal court and the federal court for the Southern District of Ohio. And she also mediated cases for the Supreme Court of Ohio's Government Conflict Resolution Services, taking high-profile cases between elected officials. And Eileen, you served as member of the Supreme Court Commission on Dispute Resolution, and you are also a founding board member of Community Mediation Services of Central Ohio. And community services mediation is still going strong today. So that has to make you proud.
Yeah, they are a primary component of the current eviction crisis caused by the pandemic. They mediate every day.
That's great. We need it. So many people need that right now. Next, I'd like to say hello to Wendy Howbaker. Wendy, did I say your last name right?
Hawbaker, you're right.
Howbaker, okay. Wendy is also recently retired after more than 30 years as an attorney and mediator. That's wonderful. Yay for you. And Wendy, you were the program coordinator of the Ashtabula County Mediation and Conflict Management Services program. What did you think were the strengths of the dispute resolution program in Ashtabula?
Well, we started with early, soon after Justice Moyer, we were one of the early groups. And so we had a whole lot of support from the Supreme Court, which was really extraordinary. Still is, but at the beginning of our program, it was very, very helpful. We also had tremendous support of our judges. So I started it with a man named John Polanski. So the two of us were new to the types of mediation that we were going to be doing at the court, and that we were just kind of out there trying to figure out how to build this program and how to do these mediations. And we were both very passionate about the process. And I think that the judges recognized that. They also recognized that this was not their forte. It was mediation at that time it had been used for a long time in certain areas of the state and the country and in certain cases. But in Ashtabula County, this was brand new, except for in family cases. So they knew that they needed to kind of hand that over to us. And that was, I would have to say, the fact that the mediators were committed and the fact that the judges were totally on board and willing to let us build a good program. Those were the strengths.
What kind of cases do they mediate in Ashtabula?
We do the full range. So we have small claims cases, common pleas cases, domestic, juvenile, foreclosure. Really, there is no case that we don't mediate. Even some criminal cases from time to time we mediate. So the whole range. And the program was set up to do that.
And before you were a mediator, you had a law practice for 10 years, and you did divorce mediation as part of your practice back in 1990s. Then you went to Ashtabula. Were you an immediate proponent of mediation?
I was working as a lawyer and a guardian ad litem in Cuyahoga County when the training was offered. And yes, I was absolutely, as soon as I took the course, I knew that this was something that I wanted to do. My husband tells me that I drank the Kool-Aid initially, and that was absolutely true. I felt like this was a process that would work, would be valuable, and it ended up to be what I did for the rest of my career.
Well, we're glad you drank that Kool-Aid, Wendy. Wendy is a founding member and past president of the Mediation Association of Northeast Ohio, past president of the Ohio Mediation Association, and she has led mediation training sessions approved by the Supreme Court of Ohio, as well as being an adjunct professor of law at her alma mater, Case Western Reserve University. So thank you so much for being here, Wendy. I would like to introduce our third guest today, Marya Coleman, not retired. Sorry, Marya.
Sorry, Marya.
Is a person that I have had the pleasure of working with before today, because as the director of mediation services at Franklin County Domestic Relations Court, she has been working really diligently to expand the scope of the court's child protection mediation program. Marya, what kind of advice do you have for people who are trying to start a mediation program at their court or expand one?
The most important thing I would think is to make sure you involve all the participants, all the stakeholders, the people who are going to be involved or could be involved. Be sure that you get your judges on board. That's probably number one. Second, be sure to talk with the attorneys, the private ones, as well as staff attorneys. Provide training for the people who will be involved in mediation, even the ones who will just be referring cases, because that's critically important. So I'd say get people involved, have them be part of developing your program, find out their concerns at the beginning, not have them be throwing them at you after you've started. So that would be my biggest piece of advice.
You have a JD from Yale Law School and a BA from Penn State. What I really love about your background is that you have been working with law students for 30 years. Can you tell us about your experience teaching and coaching Ohio State law students?
Yes, I love working with students. They have fascinating ideas. They're interested in learning. Law students just want to learn more and get involved and try things. So I love teaching them about alternative dispute resolution and other things related to dispute resolution. So it's great fun.
And you do the clinics and everything else too. What do they call the clinics where they have to actually do stuff, I guess?
I did that a while back. Right now I just
Okay.
teach classes, and I also coach the mediation advocacy team for Ohio State, which is fun. They learn to be lawyers in mediation, and that's really important as well. We need lawyers who are going to practice law, who are not going to be mediators, but who understand mediation and know how effectively to represent their clients in mediation. That's another important component of the mediation.
All right. So are you three ready to dive into our podcast topic today?
Sure.
All right. So we are talking about Chief Justice Moyer's legacy and the future of dispute resolution. To give a little bit of background, Chief Justice Moyer was a leader in providing citizens with improved access to the courts through alternative dispute resolution. And as part of his work to improve the judicial system in Ohio and throughout the country, he was a committee member of the Institute of Judicial Administration to develop national standards for the adoption of alternative dispute resolution programs by state courts such as Ohio, and a co-chair of the American Bar Association task force to develop a model mediation law. And actually, the Supreme Court of Ohio at 65 South Front Street in Columbus, Ohio, is named after him, the Thomas J. Moyer Ohio Judicial Center. And I see his official portrait in the Grand Concourse every day when I go to work. Eileen, what do you see as Chief Justice Moyer's contribution to the field of mediation?
Well, there are lots of things. Number one was his commitment to the idea that not only would the courts benefit when people sat down together with a neutral to resolve their problems, but that the people would do better, that they were more likely to abide by their agreements, that they were not going to be so involved in an adversarial relationship. There might be actually a way to preserve the relationship. So he knew that and was willing to support that from the beginning, and that was key. His work as a leader nationally can't be understated. When he co-chaired the task force, they brought the ABA together with the people who control the uniform laws in the country, a big group of people, lots going on. And he worked really hard to make sure that that group, through a collaborative process, came up with a statute that could work for most people in most situations. Ohio was the second or third state to implement the Uniform Mediation Act, and that was good too.
Eileen, can you tell us a little bit about your role in getting mediation off the ground in Ohio?
Well, as I mentioned before, there were not a lot of people at the court who were working on it, and we didn't have any funding. So we had volunteers and other people. Well, there was my salary, and that didn't last for very long. So we started training people. I'm an advocate that if you train people about mediation, they will become better consumers, they will become better mediators, they will be better able to deal with their children and their staff, because you're learning skills, you're honing skills that you already have. After we got a little money, we were able to do pilot projects, which were really helpful. We started with a small, medium, and large jurisdiction. First, we did small claims court. Then we moved on to doing common pleas court. We had people who actually rode circuit to help those new mediators and the courts get their programs going. One thing I wanted to add to Marya's statement about new programming, we found that it was critical to have not only all the people that Marya mentioned, but the funders on board. Yes. We encouraged programs to include their county commissioners, their municipal funders, to have them see what was happening, how great this was going to be, because we knew it was going to be great, so that when grant money or whatever ran out, they were in a good position to go back to their funders and see program continuation. And that was one of the most gratifying things that, of all the pilots we established and continuing programs, no longer pilots, all but one of them, I think, managed to make the shift from grant funding to court funding or county funding, or with some combination of user fee. So we were not only able to offer quality services, spread them around the state for all kinds of courts, but we were able to see them continue based on their successes.
Were there any concerns about using mediation back in the 1980s? Any perceptions that people had?
Yes, lawyers saw it as a way to try and keep them out of the cases. Judges were sometimes afraid that if they had mediators, their constituents would think they didn't have enough to do. There were issues about cases where you had staff mediators. Would the staff mediators get too friendly with the attorneys they saw all the time? How do you maintain neutrality and confidentiality when your employer is the judge? We spent a good deal of time educating people about the need for a Chinese wall between the court and the mediators. And that was a real change in the culture. There are very few judges who can't get anybody to tell them what they need to know. Your staff attorney will, your bailiff will, other judges will, but the mediator couldn't. And that was, again, as Marya said, you educate everybody. We did seminars for judges, we did seminars for court administrators, we did seminars for magistrates, all to move toward making the way a little smoother for these programs to filter into the courts. We called it the institutionalization of mediation. When would we reach the point where someone would pick up the phone and say, I'd like to get a mediator instead of I'd like to get a lawyer? I don't know that we're there yet, but we're close.
Wendy, what did you see as some of the early challenges of mediation when you first got started? Was it a different perception than now?
It was very different than now. It was very similar to the things that Eileen was talking about. We did a lot of education throughout the county. And one of our biggest challenges was the lawyers thinking that they would be seen as irrelevant and we would be taking work away from them. And we really had to work hard. We started with, and continued actually with mandatory mediation so that we would get the parties, the attorneys and their clients into the mediation rather than waiting for them to ask for it, thinking that over time that we might not continue the mandatory aspect of it. We did continue it, but we still got people, even before they were ordered to mediation, asking for it over time because they saw that it was a good process. But I would have to say that the lawyer, getting the lawyers on board and letting them know they were valued actors in the process, even when we didn't have them in the actual session, they were still very valuable. That was a challenge that we had to get over, but we did. They ended up loving it.
Now, did you have any challenges with funding as well?
We were able to, the way our program was set up was to be a program with no fees attached to it. And we were able to do that for a number of years, initially with an extension of the grant from the Supreme Court, and then we were funded, then we became funded by our court. Initially, we did not have to have a user fee, but then we went through some pretty tough financial times in the county at around the same time everybody in the state did, I think. And we instituted a fee, but in the scheme of things, it wasn't very much and still isn't very much of a fee. But other than, our court picked up as soon as the grant was over, our court picked up the funding.
Okay. Without
any problem.
And Marya, what was your experience with mediation when you first started in the game? Do you feel it was different then and as it is today?
Very much. I agree with everything that Wendy and Eileen said. And I started out as a private mediator and just convincing clients to try it, and that especially as a private mediator to pay me to try it, that they had some concerns. Then when I went to work for the court, I also found that just to make sure the judges and magistrates remembered about mediation to refer cases. And of course, as Wendy and Eileen said, convincing the lawyers that they were not going to lose their business. They were a valuable part of mediation. That is an ongoing challenge for many lawyers, and new lawyers who've gone through ADR programs in law school are willing and happy to accept it, but there's still many attorneys who think they can do a better job for their clients just by advocating.
Eileen, I'd like to talk about the Supreme Court Advisory Committee on Dispute Resolution. That was back in around 1990 or so, and that got started, I think. What kinds of things were on your agenda? Do you recall any interesting discussions or projects that did or didn't happen?
The discussions and the process were really interesting. Even before I joined the committee, the chairs had worked out hearings around the state to find out what people knew about, what they thought about various dispute resolution processes, what they wanted to see happen. They prepared a report with recommendations for the Chief Justice, which the Supreme Court voted on, and they adopted every single one except mandatory education about mediation for judges and lawyers. That didn't go into the many other requirements for education that lawyers face. But ultimately, we sort of got around that with offering free training, as I know the Supreme Court still does. And people, even if that's all the only reason they came, they usually got something out of it that they could use. There was a lot of discussion about, should we focus on arbitration? Should we work on a referral-only system? Should we just tell the courts, here's what a good mediator looks like, tell your people to find one? And some courts did create referral lists, but there were 3 or 4 things that came out that were critical. Mediation services should be free or low cost. Parties should get services that were equal to or better than what they would get in a formal court process. So nobody should be worse off after mediation than they were before they went in. Mediators should be well trained. And early on, even before the commission, when the first statute having to do with domestic relations mediation passed, there was this huge fear that judges would go out and hire their bailiffs to be mediators. And we grew to a point where there was a significant recognition that mediating took skills that were not necessarily available to everybody without training. So those things made a real difference because the committee was able to go out and preach, and they knew that the Chief Justice was supportive of that. Mm-hmm. And it made a difference. It made a difference in how our efforts were received in the courts. It made a difference how the programs went. Chief Justice Moyer would go out and present certificates to volunteer mediators in all of the small claims programs. And by the time we were sort of through the first round of that, I think he must have gone to 12 or 15 courts, and they appreciated it and he appreciated it. It's a good thing.
What a great recognition. Yeah, absolutely. I'll bet that encouraged more people to want to become mediators, and definitely would make people respect what they were doing. I mean, if the Chief Justice is saying, congratulations, here's a certificate, that's going to command some respect. That's great. That's really interesting. Okay, so there were 6 policy goals for court-connected dispute resolution that were promulgated by the Supreme Court Committee on Dispute Resolution in their 1991 preliminary report. And y'all told me about these, and I would like to go through each of these and have you reflect on them from your own experience. The first policy goal for court-connected dispute resolution was efficient use of court resources. So how does mediation help achieve this goal, and what hurdles do courts have in having efficient use of court resources? Wendy, you want to kick us off?
Sure. So that was one of the goals that the committee set up, and it was also one of the goals that our judges were particularly, a lot of things were important to them. That was, of course, one of them. And what has happened over time, the program is about 23 years old, And over time, we consistently see that the mediation department has been able to really be a great tool in the legal system to help the flow of the cases. So what we do in our program, what Ashtabula County does, is to focus on making it a flexible process so that we had the advantage of having a docket that would allow for this, but we can be flexible in terms of time and when we meet, and kind of setting more sessions if we need to, and doing whatever we can do to help the case. We did, and that's kind of sometimes a hard thing to evaluate, but we did have one type of case that really helped us evaluate that very well, which were a group of cases that a couple of our judges used. They would refer the case to mediation before they even had a pretrial. And when we looked at the number of cases that were disposed of as a result of that, that was like, they might be dismissed, they might have been settled. The attorneys might have settled them on their own, knowing that they were coming to mediation, but those cases were disposed of at a rate of more than 80%. So that was 80% of those cases that did not have to go to the judge at all, except for maybe a continuance here and there, some certain perfunctory cases or pleadings that had to be filed, but they didn't have to go into a pretrial or any kind of a hearing with the judge, and that was a pretty efficient use of the program, I thought. So that one really worked well.
Yeah, something to keep in mind with all these cases that are backlogged right now, especially the civil cases after the pandemic. Marya, do you have anything else to add about efficient use of court resources?
Well, I agree with what Wendy said. One of the ways that research shows that often when people come up with an agreement themselves, it's longer lasting, more likely to comply with it. So we also found that cases that were mediated often had fewer post-decree motions filed afterwards. They needed less enforcement, less modification. And many times when they wanted to modify it, they would start by hiring a mediator or going through a court mediation program rather than start with the court. So that was one efficient use, just by the benefits of mediation. And another, we've worked on different methods. We use a lot of contract mediators, which are financially, they're paid per case, and that gives us more flexibility and also is a good use of court resources.
Anything else for you from your side, Eileen, on efficient use?
No, I agree with both Marya and Wendy. In the municipal court, because we did pre-filing and it was voluntary, but people were encouraged to participate in mediation. The court estimated that we saved enough money in time, not real money, because that's very hard to calculate, but we saved enough that they were saved the cost of hiring an additional full-time magistrate. So all of the volunteer services and the contract services went together to allow us to provide a tremendous service to the magistrate to answer to the judges. So everybody's work got spread out a little bit more.
And that kind of leads to the next policy goal, which is a focus on public funds. So Eileen, are there any other strategies that would help the court system achieve that goal that are related to dispute resolution?
Right. I think now and in recent years, when the Supreme Court has not had grant funds to give courts, it's been harder, and they've, I think, struggled a bit with knowing how to fund. I think that the use, as Marya said, of contract mediators, having mediation programs that are really integrated and can look at dispute resolution at a number of levels within the court. Cases that come in at the very beginning might need mediation. You might be able to do it in the middle, at the end, but all of those things lead to savings that it's hard to calculate. But every time a judge doesn't have to touch a case file, there's a savings. And every time the judge doesn't have to touch a civil case, that saves more time to deal with criminal cases, which obviously have to take precedent. So I'm not answering your question, I don't think, about the use of public funds. I think we've all sort of said that nobody has come back ever, I don't think, from a mediation program and said, boy, that was a big waste of money. There are always things, not always tangible, some really cultural that have to do with changes in attitude and perceptions. But the use of public resources has yielded much more than settled cases, and much more than just getting cases off a docket. I don't think I'm being too wishy-washy, too up in the clouds to say, I really think that mediation has changed the way the courts think about their clients.
Wendy, policy goal number 3 is maintain public confidence. What hurdles do courts face in achieving maintenance of public confidence in the court, and how does mediation help achieve that goal?
I think everybody has a complaint about their case or the way their case was handled if they're in the legal system. It's very crowded. Judges are over docketed. It's not a pleasant thing to go through. It's a foreign language to them. So I think the idea of going to court, as much as people need to do it and sometimes really want to do it, it's not a user-friendly system at all. And I think the mediator's role as being a really good liaison sometimes between the lawyer and the client, between their opposing counsel or opposing party, running in between those actors, sometimes explaining things that are happening in the court, letting people feel comfortable about the process. We don't tell people what to do, but we can certainly give them information about what might happen in certain circumstances. And just having somebody who can really focus on that person, for however minimal time it is, focus on that person with their case, I think helps their whole perception of the process. People often come in and say, I want my day in court, I want to tell the judge, I want to talk to the judge. And so we let them say that. We let them go through the mediation process. And I think by the end, almost everybody who has said that, in my experience, has found that it was very valuable to them to have a mediator who could listen to their story, provide a forum where they can be heard from the other party. So I think that has gone a long way to, by extension, helping their confidence in the courts in general.
One of the advantages, too, of mediation is that it brings the parties together in what's hopefully a less stressful environment than the courtroom. I used to say that people's blood pressure goes up as soon as they walk through the courthouse doors. It's very stressful. And if two people in a small claims case or two parties with their attorneys go into the courtroom and the judge says, have you talked about this case? And they say no. How much likelihood is there that a good outcome is going to come right then? Or, it's going to be the next date and the next date. And when people come to mediation, they see each other. They have to talk to each other. And even if the case doesn't resolve in mediation, and even if it doesn't resolve before the next court date, at least they have the benefit of knowing what the other person might say in court.
Policy goal number 4 is maintain access to constitutional rights. Marya, what do you think about mediation and constitutional rights?
Well, that's been a concern with mediation since the beginning. The court system is well designed to protect the rights of the litigants so that and the Constitution is clear and the statutes supporting it are clear on many rights that litigants have. People were afraid putting them in a room with a mediator, they might lose those rights. Some of the concerns were that people might not understand their rights, the right that you can terminate mediation. You don't have to come to an agreement. They were afraid that people might be coerced or that one party might be forcing the other or kind of overwhelming the other. And those are legitimate concerns. mediators are trained to balance the power, to meet separately with parties at times, to use different mediation techniques to protect the rights, and if need be, to terminate. One of Chief Justice Moyer's, as Eileen said, many accomplishments. One of them was promoting the Uniform Mediation Act and the protections in the Uniform Mediation Act, keeping things said in mediation privileged. They can't be shared with the court unless the parties want them to be shared, but with exceptions for safety. There are safety exceptions. So that in itself has done a lot to protect the rights of parties. And I certainly have appreciated the ability, when the judge asked me a question, as Eileen said, about what happened in a case, when I be pre-Uniform Mediation Act, I just had said, I can't tell you, and I'd get stony looks from the judges. But now I can say, oh, I'm sorry, Your Honor, but pursuant to the Uniform Mediation Act, I'm not permitted to disclose that because it's privileged. And then they let me leave. So it's good. So the constitutional rights, the developments in mediation have really gone a long way to continue to protect the constitutional rights of parties. And again, well-trained mediators are necessary to implement them.
Maybe this one for Eileen or Wendy, utilizing community-based dispute resolution programs as a policy goal.
Well, Ohio has a long history of community-based programs, and we knew there were mediators out there who might actually have more experience in training than the new ones coming into the court. So there were ways that those partnerships were developed, and there was a synergy. You know, the way people in the community mediate their concerns, their processes was maybe a little different than what court mediators were doing or were thinking about doing. And so bringing those folks together in training and in co-mediating and in mediating cases just made a lot of sense. The Dayton Mediation Center had a long record before it became involved in mediation with the courts, and they were able to mediate cases involving truancy and juvenile delinquency and child protection cases too, I think. And part of it was when the parties came in to the mediation, they were seeing people from the community who, you know, didn't necessarily have a suit and tie on or whatever, a suit without a tie. But it was a really good way to bring the court into the community and the community into the court. And it worked out. I think it worked really well. And I was always very pleased that was one of the policy goals, because having worked with community mediation services and all of the programs around the state, it made sense not to let those resources slip away, to bring them in and keep them involved.
Wendy, anything to add to that?
No, that's of course well said from Eileen. We did use community members, even though we are our court program. When we started, we trained, and for a number of years, we would train a group of community volunteers to do our small claims mediations. And I think that after initially, the lawyers weren't sure that was going to work out. Once we showed them that in this group of mediators, they had been well trained, they had oversight, and they resolved cases, they were on board with that as well.
All right, and our sixth policy goal that we're talking about is to include evaluation mechanisms. Eileen, can you address that? I know you went through a couple pilot projects.
Right. Ideally, you know, I'm not a researcher, but I worked with a number of them. Ideally, you would know at the beginning of a program what it was you needed to measure. And measuring was what they would talk about. For us as program people and courts, we wanted to talk about success. And they're not always the same thing. Measuring how a program's doing, whether it's achieving its goals, is not the same as success. So we went back and forth about that, but we had some great research that set us on the path, things about that came out of mostly surveys. We're able to do very little of actually observing mediators, but parties liked mediation even when they didn't come to an agreement. So that was a good thing to be able to tell courts. Attorneys learned more to appreciate mediation more when they actually participated with their clients. So that was a way that led the way to having more lawyer involvement, which, as Wendy said, made them bigger supporters and ultimately some of our biggest supporters. mediation research showed that the background of the mediator, their educational background, didn't make much difference. You could be a teacher or a business person or a lawyer. It really didn't matter. If you had the training and the skills that are needed to be a mediator, your outcomes were going to be comparable across the board. That was really important looking back on it. We tried to look at domestic relations cases at one point, and they were very, very difficult to get a feel for what a court might or might not be doing to make things go well. On the other hand, we had research about the appellate court mediation programs in Ohio, and we went from having one to I think almost all the district courts have mediation programs now. And the first of those programs got good outcomes, kept good data, knew what they were doing, and were able then to go out and recruit other courts. And they trained each other. They talked about their settlement rates. They talked about how people often came to really understand the case. Once it was at the appellate level, there'd been a winner and a loser, but there were still things that could be done. We learned that appellate mediation can settle more than 50% of the cases. So those kinds of figures really were a nuts and bolts kind of evaluation. Whether people think mediation is fair or not, whether they think the mediator was fair, whether they think the mediator favored one side or the other. Those are all important things to ask, and we got really good answers. And again, across the board, people are happy with mediation. They believe it has value, and they believe it has value even when the cases don't settle. So all of those things, even though they're intuitive to me as a mediator and as somebody who's watched the programs, it was good to have that kind of data to go out as we were convincing the next court and the next court how they might benefit by using what we've learned to move forward. It was big, big help.
And
we should evaluate everything, in my opinion.
Right. Oh, I'm case management. We are all about data collection. So I agree with that in all states. Marya, I know you are a facts and figures and research person too. Has the evaluations of mediation helped you in training for Supreme Court trainings and working with your constituents as well?
Yes, it does. And I echo what Eileen says, and I will add that it's challenging. People don't want to fill out the surveys. It's hard sometimes to make after the fact calls to folks. Some people love to answer questions, others don't. So it's an ongoing process to keep the information, to do your surveys, and to check in with your stakeholders, other people in the court every so often, to see how you think your program is going. I think that's important. And sometimes it's easy to kind of let it slide for a while. So I fully agree. It's critically important.
Well, I think it's really interesting how all these policy goals for court-connected dispute resolution that were developed back in 1991, they're relevant today. We're still having discussions for sure about all these today, and they impact dispute resolution, on a daily basis, and all the policies we're putting in place. So our next part of this presentation is to look forward in dispute resolution. What's going to happen, now? What can we predict for the future of mediation? Marya, what are some things that Franklin County is doing now that's going to help your mediation program stay relevant in the future?
Well, one of the things is we're making sure that our private mediators, to have mediation in domestic court for cases where there are private attorneys trying to convince, and some private attorneys are working as part of this because they can sometimes convince each other better than a court personnel. And the judges are working on it too, to try to expand the use of mediation and other ADR services in Franklin County. So we're really looking into it, and hopefully there'll be exciting things to report within the next couple months.
That's great. And I know your court is really, really trying to keep the stakeholders involved and just keep that training coming up and sharing that information. People who don't know about mediation, I feel like in Franklin County are going to start knowing about mediation. So They don't let you off the hook.
Yeah, good.
You got to know it. Wendy, what do you think are the important things in the field of mediation that we need to do going forward? Are there changes that need to be made to mediation and the processes, or is it just keeping education at the forefront? What do you see as being necessary?
I think what's really imperative is that we maintain a good focus on the core principles of mediation, because while there have been a lot of positive changes, the lawyers have come on board and they're extremely helpful. A lot of lawyers have actually decided they wanted to become mediators as a result of seeing it work. On the other hand, there is also a tendency to kind of legalize the process, and that's not what mediation, in my mind, that's not the direction that we want it to go, and still maintain a really solid process. So I think the challenge is that we want to keep new mediators focused on what the real core principles. The core principles are things that you learn in every mediation training, that you're impartial, you have an impartial trained mediator, you have confidentiality, you pay attention to letting everybody be able to speak. All of those things that are very important in the training, I think if we need to keep focused on that in our practice. So that's a big challenge that I see. It's easy to whittle away at a process little by little, and the more we do that, the more we're in danger of really losing a good process.
All right, Eileen, what do you think Chief Justice Moyer would have recommended for the future of mediation?
Well, I think he'd be right in there with Wendy. You know, it's a beautiful process. When you let it work, mediation has the potential for lots of good things to happen. When we shortcut it, when mediators begin to spend too little time doing stuff, then we might be in issues. I think Chief Justice Moyer would be fascinated by the technological advances about everything that was going on anyway, and all the changes that have come about because of the pandemic. I think he would want the Supreme Court and all the local courts to be keeping their finger on it, their eye on it, to make sure that things hold true to the process. I think he would be, we didn't talk about this, I think he would be really happy to know what's happened in mediating in schools and mediation in truancy cases, and even some mediation in juvenile offenses. The idea that young people can learn, whether they're being trained in school or whether they're experiencing the mediation, can learn from that and go into their adult lives as better consumers of this service, was really important to him. I think we've seen that. I think the Supreme Court's supported it more and more. I think that schools where they've been able to set up programs that are supported, just like in courts, have seen wonderful things happen. You know, attendance will improve, parental involvement improves, teachers have a better feel for what's going on in a student's life, you know, and that's a lot to ask, to think you might get out of a single meeting or two meetings of a parent with a teacher and a student involved. So I think he'd be very happy to see that moving forward.
Obviously, with the pandemic, we went a lot to online mediation. You were talking about technology. Do any of you have any opinions about whether the pandemic changed the expectations for what can be accomplished with mediation, or what we're going to see?
I can start on that one. I know that Ashtabula County has always had the requirement that whoever is necessary to the case be at the mediation in person. And even we're, for various reasons, for good and bad, maybe, we have done in-person mediations almost from the beginning of the epidemic, the pandemic. So we've continued to do that. So I think, yeah, so I think that's a really important one to keep in mind going forward.
And Marya, what did you want to add to that?
I would add, since we have done no in-person mediation since March of 2020, we've been doing only virtual and working hard to have the protections, make sure we do the mediation pre-screenings to involve the parties and protect their rights and make sure they feel involved in the process while on Zoom or other platforms such as that. I do think a platform where the parties can see each other and at least see the mediator if the mediator needs to keep them separated, which sometimes you have to in real life and in person, and sometimes even on a virtual platform. So I think it's important to just keep all the core values in mind, to all the mediation protections for the parties in mind. And yes, there's definitely a value to in-person, the little nuances you may not catch on a virtual. But for the most part, I think virtual, at least in our court, will continue. We hope to have in-person as well very soon, but we want to be able to offer both.
Well, we're getting towards the end of our podcast, and there's a bit that I like to do at the end of every podcast that I'm going to subject you to as well. And it's called 2 for me and 1 for you. There'll be 2 questions for you, the presenters, and 1 question that you will have for the listening audience as a pop quiz to see if they were paying attention today. So the first question I'll direct to each of you in turn. What is an interesting and relatively brief mediation-related story you can share? It can be about being on a commission. It can be about doing a mediation, directing people to be in mediation, whatever you think would be interesting from your varied histories of mediation. I'll start with you, Wendy.
Okay, I have, thank you for giving us a heads up about this, because I have so many of them that I would want to think through. But I do have one that really sticks in my mind. This was an insurance case, and in the insurance case, oftentimes we do not, at least when I was doing mediations in Ashtabula County, most of the time we did not have the actual defendant there. So we had the insurance company representative and their lawyer, and the plaintiff and the plaintiff's lawyer. So in this particular case, the insurance representative was there. The case was nothing really extraordinary from an injury standpoint, but the plaintiff had questions that only the defendant could answer. And she did not want to settle this case. She wanted these questions answered that had to do with why did the defendant do certain things that caused this accident. And the case was absolutely not settling, much as everybody was trying to get it resolved. So what we did was conclude the mediation for the day and set another mediation where the defendant came in, and the defendant, and who was the driver of the car that hit the plaintiff, was actually able to sit face to face and talk with the plaintiff, and the plaintiff had her questions answered. It was actually very touching because the accident happened because the defendant was on his way to visit his mother, who was dying. And it was very touching, and it really meant a lot to both of them, actually, to sit face to face and be able to share what happened in that accident. And that case settled immediately. She just really wanted to speak to the person that had hurt her.
Thank you. Thanks for sharing that. All right, Eileen.
I had 2. I think I would never have thought of to talk about anything having to do with the commission or my managerial duties. That's really, no, we're not going to go there. I had 2 cases that shared a lot. One was that they were both in very strange circumstances at the time for mediation. The first one was in a huge conference room at the Supreme Court, and the parties really were COVID distance. I mean, it was a big room. And the second one was actually in a courtroom, which I never think of as a good place to do mediation. And in both of those cases, the first one was a workplace injury case. In caucus, the plaintiff said, they never called me. I didn't get a get well card. Nothing happened. This is a really serious injury. I haven't been able to go back to work. What is going on? And we brought that back to the table from caucus. And I said because they asked me to say it, I said, Mr. So-and-so is really concerned that nobody came to see him, nobody called him, nothing. And the defendants were able to explain that because it was an accident, their attorneys had told them not to have any contact with this gentleman. And they were very sorry about the accident, and they were very sorry about what had happened to him. And he heard that, and it was a turning point for the case. They were able to settle the case because the plaintiff, as in Wendy's case, got through it and was able to hear what else was going on. The case in the courtroom involved horrible situation, not much money, but a daughter was being sued to collect fees due to the nursing home where her mother died. And it was not going well. It was not going well. And she finally said to everybody in the room, I think you're glad she died. And she said it very loudly. And it just took us all aback. And, that was it. Everybody sat up, took notice, went forward. At that point, I wouldn't have even had to be there. I mean, the thing is that it's never just about the money. And those are two cases that really brought that home to me. And I have always carried it with me as a mediator, that you can never look only at what's on top.
Thank you. All right, Marya, your turn.
Probably an event that occurs in many cases, or that we hope will happen in cases, is when I do family cases, and in parenting time mediation, folks often come in and the parents come in and start talking about what they need, what they want. The parent needs and wants. They want equal time with their child. They have a right to see their children. And sometimes if we can help refocus them, suddenly there's a moment where they stop looking at what they want and jointly start looking at what the child needs. And when that happens, I keep trying to direct them that way in the mediation, not to direct them to do that, but asking questions. When they can see, they suddenly start focusing on the child's needs. Sometimes at that moment, they can both start planning together. And as Eileen just said, sometimes I don't even need to really be in the room, because they're suddenly both talking about a child who they both love very much, and that's who they're focusing on. So when that happens, I know that the mediation has helped that child's life.
That's a good day's work, for sure.
Yes.
All right, the next question is, who is an amazing person related to the field of mediation, and why do you appreciate them? We'll start again with Wendy.
Oh my goodness, I really had a hard time with this one because I've had so many people show me so many things, including the two women that I'm here with, Eileen and Marya. They've been wonderful role models as well. So I am picking somebody who, and also there's a lot of people who are big names in mediation who have been influential to me. So it's a really tough question, but I am going to pick a guy who I trained a lot with, and I worked with him in a community mediation organization. His name's Eddie Boyd. The reason I pick him is because not only is he an excellent mediator, but he really exemplifies like a non-judgmental attitude and paying attention to people and trying to level a playing field. The things that mediators do, he really kind of does that in his practice and in his life. And I have really benefited by knowing him.
Next, I'll turn to Marya.
Like Wendy, I thought of so many people, but since we were talking about Chief Justice Moyer, I'd like to talk about Nancy Rogers, who has worked closely with Chief Justice Moyer on the Uniform Mediation Act, and she's one of the ones who worked with him in the beginning with mediation, and has done so much for mediation in the state of Ohio, and yet she's quiet and tends to try to focus on what other people have done. So she's just an amazing person, and has also, like Chief Justice Moyer, probably led a great deal of the mediation work in Ohio.
All right, thank you. And Eileen.
Well, I would agree with both Wendy and Marya's choices. I know Eddie as well, just a little bit, and Nancy Rogers has been an inspiration to all of us in the field. I think I want to talk about a mediator named Dave Doyle, who's at the 10th District Court of Appeals here in Franklin County. Dave started mediating after the chief judge in this court said, I hear there's a mediation program in Cincinnati at the federal court. And I think Dave was a law clerk at that time. And he sent him down and had him check it out, sent him to Harvard to the negotiation program. Dave came back. He was just like 2 years out of law school, and he started mediating, and he's mediated through some serious health issues, and he's always pleasant and treats each person with so much respect, and was mediating by telephone. When he couldn't even put people on hold, he was literally calling them back. Things were so underdeveloped. it just epitomizes the best of what we can be when we are careful to listen to people and be non-judgmental and walk through the process with them.
All right, now all three of you are educators and mentors to other people and trainers for the Supreme Court. So I don't know who is going to field this question, but we only need one pop quiz question. So what is a question that our audience should be able to answer after listening to this podcast? Who wants to take it?
I don't think we really talked about it. I think we had all thought about it. We'd given this a lot of thought together, and we thought we would come up with an answer. And I think, please add on, Wendy and Marya, because I'm not sure I got it all. There's a real challenge here to move forward and build on the past. And our question to you is, how will you accept this challenge and go forward to keep the core values of mediation, neutrality, self-determination, confidentiality in place and at the forefront as new and exciting processes develop? Nothing stays the same, but what are you going to do to keep some important things the focus of what we do as mediators?
That's a great question. I hope our audience thinks about that one. All right, well, does anyone have any closing words before we sign off today?
No. Thank you for doing this, though.
Oh, thank you all for being here. All right. Well, that's a wrap for today. Thank you so much to Eileen Pruitt, Marya Coleman, and Wendy Howbaker for this inspiring history lesson. And thank you to all of you out there listening. I hope you will join us for the next episode of the Civility and Solutions podcast. Until then, keep working for justice.